Thank you very much indeed. I am actually a recognised authority on the destruction of heritage assets because according to the correspondence page in the Times, the Law Commission in its final report on planning law in Wales, which I was perhaps largely wrote, had at a stroke led to the destruction of the entire historic heritage of Wales. So, you know, go for it. I thought I was trying to help. I also noticed, I think I'm the only person here who's got any connection to Wales at all. I'm looking for the attendances. Is there somebody here from Wales? They are. Good. Put a hand down. Right. I also, it was nice to hear from the previous speaker. I didn't realise that Mount Rushmore was in Scotland, but you know, you learn something new every day. What I've been asked to talk about is the destruction of the heritage assets and what you do about it. I'm getting on here. Do I? Right, okay. Lawyers don't know everything. So, yes, this is a typical example of a heritage asset that isn't there anymore, and you will have all seen sites like that. That's the problem. What I'm trying to do is to focus on what the remedies are to local authorities and others when this sort of thing happens, and equally, of course, for those of you who are engaged by owners of properties, how you avoid those consequences should you feel that appropriate. Clearly, as a lawyer, I make no comment as to whether it's a good thing to be on one side or the other. It depends entirely who gets to you first. Well, I do have views, but now I'm a civil servant, I'm obviously not allowed to say anything. What are unauthorised works? It's an easy term to use. Unauthorised works are works without permission, without authority. But there is a huge difference between works without planning permission and works without other forms of consent. The problem with works for heritage is that they can't be put back. So, development carried out without planning permission is what's called euphemistically a breach of planning control, and you can, should you wish to, make it the subject of enforcement action. That is to say, the local authority serves an enforcement notice, and if the punter doesn't actually comply with the enforcement notice to put the building back, you can then be subject to a prosecution. Works to a listed building, on the other hand, without listed building consent, and of course unauthorised demolition in a conservation area, can be the subject of either enforcement action or prosecution. They can be either. But with normal planning permission, you have to first enforce, then prosecute. Listed buildings, you can go straight to prosecution should you wish to. What is listed building consent? Listed building consent is required for works for the demolition of a listed building or works for its alteration or extension in any manner which affects its character as a building of special architectural or historic interest. Note, not any alteration. That is different from planning permission because, of course, it will include works to the interior and it will include works to curtilage buildings. I'm not going to spend any time on curtilage. Some of you will be relieved to hear. I think I can do curtilage, but not today. But you first of all have to know, though, what is the listed building. And the listed building, of course, as you all know, is the building in the list and the buildings attached to it and the curtilage in its curtilage and so on. So, first of all, what is the listed building, and then are you demolishing it or altering it or extending it in a manner which affects its character. Why? Why does this matter? Why do you have criminal liability for works in listed buildings and not for planning permission, for breach of planning permission? One of the things that constantly crops up in various forms of public consultation is you will invariably find that the grumpy colonel in the corner will say that all breaches of planning control ought to be a criminal offence. Usually if the colonel's grumpy enough, it ought to be a capital offence. But it isn't. And there's a very good reason for that, because there are, in fact, the rules on planning permission are so complicated and so diverse that people all the time do things without planning permission, either because they know what the rules are and they slightly bend them, or alternatively they just can't work out what the rules are because they're so complicated. But one way or the other, people break the rules all the time. It would be intrinsically very unsatisfactory if every time you break the rules it's a criminal offence. However, with listed buildings, you can't put them back. Once a building has been demolished, or once its significant features have been altered, that's a one-way process. You can put them back in facsimile, but even that is only facsimile, it's not historic fabric. So in principle, it's obviously sensible for work to the heritage to be a criminal offence, simply because if it isn't a criminal offence, then there's really no incentive not to offend in the future. If you put up a tower block, you can always take it down again. If you demolish a historic building, you can't put it back. The same, of course, is true of protected trees. But, on the other hand, don't go too far. Because do remember that not all buildings are listed. There is inevitably an element of selectivity about it. Not all works of a listed building actually affect its character. And even those that do affect its character may not affect its character very much. All buildings, of course, are old. That is to say, this building I'm now standing, you're sitting now, is a historic building in the sense that it was built at a particular point in time for a particular purpose. Every building has history, every building has age. Some buildings are older than others, some buildings are more interesting than others, but every building is historic. Really, because some buildings have a label round them saying this is listed, means that, at least in theory, if you put a new B&Q kitchen in a listed building without listed building consent, it's a criminal offence. If you put a B&Q kitchen in a building that's just avoided being listed because it's not quite interesting enough, that's not a criminal offence. If you start to think about that from the perspective of the householder, that seems a bit odd. And I think one does have to bear in mind that an awful lot of people do an awful lot of things to listed buildings which technically need listed building consent and which undoubtedly are a criminal offence, but they will be quite surprised and might be rather more than surprised, outraged, to be on the wrong end of a prosecution. That said, of course, you know the heritage is irreplaceable, you ask not to who the bell tolls, it tolls for thee and all that. You do have to protect against unwanted loss and harm. So there has to be a balance struck. But do remember there has to be a balance struck, and it is neither possible nor sensible to control everything. And therefore all powers, whether they're using enforcement or prosecution, must be used sensibly. And remember that your ambition is to deal with justice as well as law. In practice, you may get deliberate demolition, you may get outrageous demolition as a prelude to redevelopment, that's fairly rare. You may get, quotes, accidental demolition, which is slightly less rare, including sometimes collapsed or unpermitted works. Or you may get the results of just insufficient care, or it might actually be a genuine accident. They do happen. As opposed to a, quotes, genuine, unquotes, accident. Particular situations you get, a building is burnt before or after being listed. It's curious how many buildings do seem to extraordinarily catch fire just before they're listed or just after they're listed. Not entirely by accident. These things happen. Insurers are always very interested to know about that. Sometimes you get an accidental fire, which actually is a genuine accident, followed by the removal of what remains, which may or may not be accidental. Happened at a case I was at some years ago in Silchester. It burnt down, most of the building burnt down overnight, and then the rest was removed in the morning. You get buildings demolished for safety reasons, which may be genuine, may not be genuine. We've seen already today a number of slides of buildings which are in various states of decay or disrepair, and it's easy to allege that you have to remove them for safety reasons. You get buildings which are sold in kit form to be exported to America, usually America, or somewhere else, which is a form of demolition. You get breach of conditions or listed building consent. That's actually very common. The punter gets listed building consent, but then breaches the conditions of the consent. And what the authority has to do is to prove beyond reasonable doubt, on the criminal standard that is, that the building was listed, that the works were carried out for demolition. That means it was actually intentional, not a genuine accident, and that the accused actually carried out the works or caused or permitted them. But it can be quite tricky with larger projects. You often get the owner says it was the architect's fault, the architect says it was the owner's fault, the owner says it was the owner's wife's fault, and said it was her husband's fault, and so on and so on. The one thing you can guarantee is that nobody had listed building consent, so you prosecute everybody. And then you let them sort it out between themselves, which can be very messy. You don't have to prove that the accused knew it was listed, and indeed it may be prejudicial if you do prove that. So don't go down the mistake a lot of people do of saying he knew it was listed, and he knew he didn't have listed building consent, and he knew he was doing the wrong thing. If you do that, then you will not succeed in the prosecution, because it's what lawyers call an absolute liability offence, and you have to actually make sure he considered it. Was it listed? Yes, no. Did he do the works? Yes, no. Did he have listed building consent? Yes, no. So what you've got to do is to show it was listed and he did it. It's usually a he. What the accused has to prove is on the balance of probability is that he had, or she had, I suppose, consent. And that should be easier for the defence to prove if you've got it. In other words, it's not for the authority to prove that he didn't have consent, it's for the defence to show that he did. You may be able to get away with proving, if you're for the punter, that works were urgently necessary and that you couldn't rely on repairs to make the building safe, and that you did the minimum necessary, and that you notified the planning authority. But that's quite a high, you've got to prove all that lot, and that may not be that straightforward. Demolition in the conservation area is the same. It obviously needs planning permission in England, conservation area consent everywhere else. Unauthorised demolition is an offence. It's the one example of where failure to get planning permission is a criminal offence, and then you prosecute exactly as for listed buildings. You've got to show that the building was in the conservation area, and the punter did it, and then the punter has to show that he had consent. More common than demolition is alterations, because actually the number of unauthorised demolition per year is vanishingly small. But alterations are much more common, basically as for demolition, but the authority must be able to show the works affected the character of the building as a building of special interest. And of course, you get evidence on both sides. I think the works were very minor and fairly trivial, and you think they were, I, the punter, think they were totally trivial, didn't affect the character. You, the planning authority, think they were outrageous and awful. And so you need to have proper evidence as to the effect on the character, which can be quite tricky to admit in a criminal court. You particularly need care where the works include a negative and a positive bit. Very many building projects involve a negative bit to start with, a sort of dismantling of a building, and then you put it together again. You first of all strip off the old plaster, and then put on new plaster. You strip out the old windows and replace them. The courts have said, not to universal enthusiasm, but the courts have said that when you've got a negative followed by a positive like that, what you must do is to look at the works taken as a whole. When I was at the bar, I used to frequently get run up by local authorities who, in a state of high emotion, and say, oh, we've just been down to so-and-so hall or so-and-so manor, and they've ripped it all out and it's absolutely terrible. And I say, well, okay, yes, that's the negative bit. Any building works, to any building, when you look at it at that point in the proceedings, looks very frightening. But what you have to do is to think, what's going to happen when it's all over? Once everything's been put back and everything's covered in law ration wallpaper, will you actually know that they've actually done any work at all? So you do need to think quite carefully. Don't go in trigger happy and try and prosecute halfway through. On the other hand, if in fact they're not going to replace it, of course you do need to go in and be very trigger happy. So there is a delicate balancing act. You need to think, is this somebody who's basically doing a remove the old and replace it with new, or is this somebody doing a rip out all the old and then by goodness me not replace it with new because it's too expensive or outside with something else or redevelop the site. So there's sort of element of intelligence needed there. And if you have, if the punter thinks the works weren't very important and the authority thinks it's absolutely terrible, you may have to have an argument about the basis of a guilty plea. So the punter may say, well, all right, I'm guilty, I did the work, but it wasn't very important. And you can have quite a lot of trouble of that. If the owner or the person responsible can show that he genuinely believed the works were necessary to avoid death or serious physical injury, and that the response was reasonable and proportionate, then that is what's called a defence of duress of circumstances. I had come across that once in a listed buildings case. In other words, the building half fell down in a fire. I had to knock down what was left because I genuinely believed it was about to collapse. Obviously, what that defence was designed for the person who was usually designed for a straightforward physical violence case. I think you're about to hit me with an axe, so in order to avoid that, I hit you. That's what it's designed for, but it does also work for listed buildings. In order to avoid that, the local authority should, it's quite simple, you just simply visit the site, the owner says, it's about to fall down, and the local authority say, there, calm down, here's a piece of paper where we take full responsibility for the future of the building, it won't fall down, it's perfectly safe, and I've signed it and that's it, so you can't use that defence. Now, no local authority is going to do that in the real world, and so if a local authority are not prepared to take responsibility for the safety of the building, because no local authority they've got their brains on is going to say it will not fall down. They might offer the opinion that it probably won't fall down, but they're not actually going to sign a piece of paper saying it won't fall down. And you can't really blame the punter if he says, well, I think it will, and so I'm going to remove it. So that's a potential problem, but it's quite rare. So hopefully you won't be faced with that one. But the real lesson from that is if the authority think it's safe, have a good reason and be prepared to persuade the person that it is. The standard test if you're prosecuting is there a reasonable prospect of conviction? In other words, is it going to work? And secondly, would it be in the public interest? So how serious is the offence? What is the culpability of the defendant? What is the impact on the community? And is prosecution a proportionate response? And do remember that, because I think I have seen over the years a number of listed building prosecutions that seem to be very doubtful in the public interest. They cost an awful lot of money for both sides with very little real gain. There is no time limit on listed buildings prosecution, but delay is clearly undesirable.
Charles, sorry, can I just quickly ask, would you advocate then getting statements of impact at the stage of initiating prosecution rather than waiting for sentencing?
It may well be, that's right, because you need, while everybody's on site and talking about it, you actually want to sort of say what is the impact and so on. Because you've got to show, I mean, you don't actually have to stand up in court as the prosecution and prove it's in the public interest. So there is no formal procedure for that. But there nevertheless is this standard test. And I think it would be wholly wrong, although you might get away with it, but it would be, as a matter of principle, it's wrong to prosecute if it's not in the public interest. And the way you do that is to sort of, is you convince yourself by actually making sure that you basically said, why is it serious? How culpable? Because if the culpability is the one the court's most interested in. If it's a little old lady who has been misled by a double glazing contractor, she's not really liable. If on the other hand it's a witty developer, he knows what he's up to. Then we get to procedure, which you've all seen that one. You usually agree most things, but just worry about things you can't agree. You now have the same maximum fine, whether it's in the Crown Court or in the magistrates, so always go to the magistrates if you possibly can, whether you're the defence or whether you're the prosecution, it's always better to go to the magistrates. And the fines are now slightly higher in the Crown Court in terms of prison, but nobody ever goes to prison, and therefore it's an unlimited fine in either case. And those are the factors you have to consider in the sentence, which are somewhat similar to the factors you have to consider whether it's a public interest. And then the sentencing varies from 100 quid, where the prosecution was told that this was a gross misuse of public funds, up to 200,000. Have a look at the Bodkin's database on the IHBC website, for example. Prosecution of Offenders Act, you can, the prosecuting authority can get a confiscation order for any major increase in the value of the property resulting from the offence. There used to be, the early cases were told it wasn't suitable for a prosecution of a crime act order, grants no proper order. The most recent one was not a listed buildings case, it was a general planning one, where the prosecution of crime act order was in the sum of £4.3 million. And so if by demolishing a listed building that's led to an increase in the value of the site, possibly for a supermarket, then you can get that back as a prosecution of crime act order, and the prosecuting authority get about a third of the proceeds, which is worth having. But the Court of Appeal are getting very unkeen on that. The alternative to prosecution is enforcement action, and I am aware of you sitting there. If you so much as put a hand on me, I'll prosecute you. And I've got friends who can deal with it. The alternative to prosecution is enforcement, but that's likely to be only useful if you can actually get the harm rectified. There's no point in enforcing if the building has been flattened or the details are gone. So enforcement is unlikely to be terribly helpful, but it may be occasionally, particularly breaches of condition, where you can often get some improvement done there. And again, you've got to consider the decision to enforce, and those are the various things you have to take account of. Do the delegates have these notes in their pack?
They will be getting those notes.
Right, so you will get these, even though I won't be able to get to all of them, but so don't panic. And then, of course, you appeal against enforcement notice on all the usual grounds, like a planning enforcement notice, somewhat similar. And then you have an appeal to the Secretary of State. It's much more useful to go to have an appeal, an inquiry in front of the Secretary of State's inspector than it is in front of the magistrates. Magistrates really are not a good, suitable forum for this sort of thing. And then the local authority can enter the land, carry out the works, and if you don't carry out the works required by enforcement notice, that is itself an offence. For urgency, you can do stop notices, injunctions and so on. Again, basically get legal advice if it's urgent. There are things available, but it's a procedural nightmare. And most importantly, do remember, it may be suitable to just simply say, why not get retrospective permission for something? Because spending 20, 30, 40, 50,000 quid on enforcement or prosecution, both sides, is terribly unprofitable use of money. It would be much better to actually say,
what do we do now, given we are where we are, how should we spend that 50,000 on actually restoring the building? Because usually what you want is the building back, not the punter put in jail. Here's an early photograph of Bob Kindred. This was formerly we suffered from crimes, now we suffer from laws. And in order to avoid crimes, we've had to have so many laws that we now have too many laws. That was said by Tacitus approximately 1900 years ago. So maybe there's nothing new, really. And if you want the full version, you can, it is now available.